Welcome, everybody, and thank you for joining us for this presentation. This is about Lanham Act, and we've titled it, Who Misses Law School? A Practical Application of the Law to a Lanham Act Hypothetical. We've been doing these Lanham Act claims for presentations for some time, and we thought we'd try something a little different this time. But first, let me introduce myself. My name is Roger Colaizzi. I chair our advertising litigation group here. I've been a litigator for almost 4 decades now, starting at the Justice Department and then the U.S. Attorney's Office. Went to private practice, and for the last 25 years have been doing false advertising, intellectual property, other Lanham Act claims, copyright claims, and patent issues. And William's been with us for some time.
My name is William Lawrence. I've been practicing since 2013. I've started out doing white collar investigations and securities work, but quickly moved on to doing advertising litigation and intellectual property litigation. Came to Venable a few years ago, and I've been working with Roger ever since. And we've been handling a lot of these cases and doing a lot of these presentations for people like you.
So we've got a hypothetical here. And so rather than just hear us drone on about what the elements are for a Lanham Act claim or a false advertising claim and various ways to present a claim as plaintiff or defend a claim as defendant or deal with the elements of the claim, we thought we'd put it in the form of a hypothetical. So we put together this situation where the plaintiff is going to be a company called Sandstorm, which is the largest manufacturer of sandblasters in the country. And Conway Power Blaster is the defendant. They're the upstart, and they sell a new combination of pressure washer and sandblaster. And as a result, they're making a lot of marketing claims and really pushing the product out there. But there are some questions about the product's performance, and using this as the example. So here's an ad, makes a lot of pretty wild claims, as you may be able to see there. And we're gonna wanna go through these one at a time. And so let's start with some guidelines.
So the guidelines we're going to be using for the hypothetical come from the Lanham Act, and we're going to pretty much be evaluating all of the representations that you saw in the ad. We'll be identifying the representations we think are problematic and kind of evaluating step by step whether or not they would potentially be a violation under the Lanham Act, and if they are, what sort of damages and how we get there. So first, just going through the elements really quickly and giving you some context. Under the Lanham Act, it really governs any sort of misrepresentations as it pertains to commercial advertising between competitors. And so it has several elements. And the first element is that there has to be a false or misleading statement about the product. Now, the interesting thing about that element is it has to be an actual statement of fact. It can't be a statement of opinion. It can't be puffery. It has to be something that's actually concrete, a statement about the product that you can point to and say is false. The next element is that there has to be actual deception, or at least a tendency to deceive. Now, oftentimes in these cases, it may not be as clear whether or not it will actually deceive a customer. And in those cases, oftentimes we'll get a consumer perception expert, we'll do surveys, and we'll try to show that whatever was said that we're claiming is false actually would deceive the reasonable customer, at least to a reasonable degree, such that it would be a violation of the Lanham Act. The next element is that the deception has to be material. And usually the metric for that is it's likely to influence the purchasing decision. Oftentimes, these are very primary factors, such as what is the actual price of the product? What is the actual performance of the product? Things that consumers are going to look at and want to know before they buy something like a sandblaster. They want to know that it actually does it well, that it actually removes enough of whatever you're trying to remove to make it actually worth buying. Those are sort of fundamental things about the product that consumers are going to look at and decide whether or not they want to purchase the product. And then this one seems simple. They must actually be selling something. It must be something that is actually presented in interstate commerce, something that's actually available to purchase so that the advertising actually has to do with the product they're purchasing. And finally, there has to be some sort of injury. And we'll talk a little bit later about what sort of damages can be alleged and what the standards for those are. So let's start with the representations that we identified. Now, the first fact that you'll see on the presentation is the Conway Power Blaster could shoot water, sand, or any other substance you want to propel at a given surface. Now, we haven't circled this one, but we thought it was just kind of odd. What else would you put in here besides water or sand that you really want to shoot? So, that's kind of an interesting question that we didn't really sort of touch on, and whether or not you can put absolutely anything into this blaster seems a little suspicious, but we're going to go to some classic representations to kind of see how they might affect the Lanham Act claim. So the claim that we have circled is the Conway Power Blaster removes 100% of paint from any surface better than any other competing brand. So that's where we're going to start in terms of our evaluation.
So that is a comparative superior performance claim. And so it's a superiority claim because it claims to be better than anything else on the market. And I want to talk here about a little bit about the burdens of proof, right? And so typically in a Lanham Act claim and a false advertising claim, the burden's on the plaintiff or the challenger to demonstrate that the claim is false or has a tendency to deceive, whether the falsity is an expressly false claim or an implied claim. The burden's on a plaintiff to demonstrate that. Now, the burden can shift if the claim is a test-prove claim. A test-prove claim can be something like, and it's also referred to as an establishment claim, is something like tests show that our car is faster than any other car in the world. Right, so there must be a test there that does it. Now, an establishment claim or a test-proof claim can also be implied. And on this one, you can see this is implied because it's suggesting that, it's stating that the Conway Power Blaster removes 100% of paint from any surface better than any competing brand. And there must be some sort of test to prove that. Otherwise, how could you possibly measure it? So the consumer is going to take away that, oh, there must be a test. So they're going to imply a test. There is a test, and the test proves that the Conway Power Blaster can blast away paint from any surface better than a competing brand. And so when we look at it from that perspective, right, we have to look and see if this is actually true. And how do you prove that? Where's the test? Well, let's just start considering the testing, right? And when we first look at consumer products or services, we look at what the basic issues are. So is there an industry standard test? For example, if you're looking at how well a vacuum cleans carpets, there is an industry standard test that establishes the correct protocol for proving that. If there isn't an industry standard test, is the test protocol something that's methodologically sound? In other words, does it follow scientific principles? Does it demonstrate it does what it purports to do? Did the study actually test the products at issue here? In other words, was there a test against every other brand in the marketplace? Is there a correlation between the test results and the challenge claims? So one thing that you have to think about when you're first looking at a test-proof claim is there a test at all? Oftentimes someone will make a claim and there's no test. Well, if there's no test, whether it's expressly stated like test-proof or is implied from the claim that we just looked at, if there's no test, the claim is literally false and the plaintiff is going to win that claim. And then if you're looking to see if it's the right test, if it's consumer relevant or clinically meaningful, that really is, does it test the right thing? In other words, is the test going to demonstrate that the product is working or not working? And in this situation, the claim is that Conway removes 100% of the paint from any surface better than any other brand. And so let's consider that maybe this is the test that's demonstrated. So here you have the Conway Power Blaster showing 100% test results of removing paint from wood surfaces. And the competitor is only being able to remove 99% of the paint. So does that mean that this test proves that the Conway removes 100% of the paint from any surface better than any other brand? And you would say, well, it sure looks like it, but maybe not. When you think about the claim, it's from any surface. This test is only testing wood surfaces. Have they tested metal or plastic or glass or fiberglass? And so if you're going to make a claim that's better than better at any surface, from any surface, then you have to have a test that's going to demonstrate or substantiate that claim. And it's when you think about removing 100% better, if they both remove 100%, for example, as this next slide demonstrates, how do you say it removes it better than the other? So this test, again, is the wrong test. It doesn't establish the claim. It doesn't demonstrate, in other words, however they tested this, if they both remove 100%, how can one do it better, right? And so you have to really look at the tests that you're utilizing or that the other side is utilizing to determine whether the test proof claim can be substantiated. All right.
And so here we have kind of another example of a similar concept that Roger's talking about. And here the claim is that the Conway Blaster is more durable construction than any other brand. Now, that's an interesting claim because it doesn't exactly give the same percentage points to how much more durable it is. It's a little bit less specific, but what it does is it implies that there's some sort of test not only of the durable construction of the Conway, but also in comparison to every other brand that is on the market. And so in order to have a reasonable basis to make those claims, you have to think, well, what type of test is this? Is this a test of the actual construction materials that go into it? Is this some sort of impact test on the actual device? Is it actually a test of how many times it can be used before it breaks down? And then you have to ask, well, what is the category? Are we testing it against every other sandblaster? Are we testing it against every other water pressure shooter? Are we testing it against any other sort of device that does similar functions in terms of cleaning paint or things off the surfaces? All these are going to be questions that are going to be asked and are concerns that need to be addressed before such a claim is made to ensure that the advertiser can actually reasonably say that their product is more durable than any other. And then the question becomes, is this even a claim that is subject to being able to be tested? Is this something that you can actually reliably test such that you can fairly make the claim? And if not, perhaps it's not something that you should be saying in your advertisement.
I suppose also that whether durability of construction is a factor or something that consumers are looking at. If all the products out there have the same or similar construction, it's really about how well it performs with a sandblaster or a power washer, then maybe the durability of construction is not a factor that's meaningful to consumers.
And so going to sort of our next fact right here, the next fact is 73% of Conway Power Blaster users prefer it to Sandstorm Power Blasters. Now that's a pretty direct consumer preference claim, and it seems very clear that a reasonable customer is going to expect that at the very least, they actually surveyed consumers of the Conway Power Blaster and the Sandstorm Power Blasters to actually come up with some sort of reliable metric to determine that 73% preferred Conway over Sandstorm. So let's look at what they actually did. Here's an example of a survey. Now, looking at this survey, what the survey says is 24% prefer Conway, 24% prefer Sandstorm, and 52% don't care. They just want something that's going to clean off their deck. Now, if this is the survey that was used, does it support that 73% of consumers actually prefer Conway? I think the clear answer here is no. It's clear most people don't even have a preference, and looks like they're evenly split in the market.
So there's this other survey that looks like Conway put together. And question 2 is of the same survey. Between Conway and Sandstorm, which brand of power blaster do you prefer? Well, there's the 73% number. Well, that's a pretty good response. So does that mean now that they've proven their claims? Well, probably not. And why is that? And we're going to get just briefly into consumer perception surveys and surveys in general. But even though it looks like this substantiates the claim, we have to say, well, what's wrong with this survey? So first of all, as you may recall from the claim, it says 73% of Conway Power Blaster users prefer it to Sandstorm Power Blasters. So the suggestion there is that this survey only surveyed Conway Power Blaster users. And that would not be a well-done survey because it's only asking Conway users which they like best. That's full of a lot of issues. First of all, it's not the proper sample area with respect to who should be included as survey respondents. More importantly, it also biases the responses to Conway. Research has shown that once somebody has purchased a product, they're going to think it's better than the product that they didn't purchase. And when you look back at question 1, if you were to ask which blaster you prefer, it's mostly no preference. So what's missing from the second question is there's no opportunity to say, I don't have an opinion or I don't know. And that option is almost always provided in surveys because you have to choose one when you're looking at question 2 here, and that forces you to choose either Conway or Sandstorm. You don't have the option to say, I don't really have an opinion like you did in the first question. And so when you think about it from the standpoint of what you have to prove in a survey or a consumer perception survey, there are guidelines that you can look at, and the courts often rely on a complex case series that also includes the proper way to do consumer perception surveys. So if federal courts have specific guidelines on what to look at in surveys, then as an attorney or a company representative, you want to make sure that you are following those guidelines. And Sherry Diamond is a person who has been doing that chapter in the complex case manual for a number of years. And this is just roughly what's required. You have to have a representative population. If you're only using Conway blaster users, then you don't have a representative population. It should be everybody who is using a sandblaster or a power washer at minimum, right? And do you use non-leading questions? Well, that one question we saw, the last one, this could be leading in the sense that you have to have pick between one or the other. It doesn't give you a different option. And while it's not technically a leading question, it's a biased question. Proper coding and analysis that has to do with what you do with the results and what the analysis is, whether you have open-ended questions where somebody has to write in the answer, or it's a multiple choice question, and whether the answer is leading or not. And then the fit between the survey and the relevant question, and that is, we go back to the claim that 73% of users prefer Conway to Sandstorm, even if it's just Conway Power Blasters. It's not much of a claim because it's not unbiased.
And I think the important thing about that when considering these surveys is you can do a survey that sort of tests something as simple as who likes this brand versus that brand, and you can get a statistically reliable answer that you absolutely like and you want to put it in an advertisement, but you can still put it in an advertisement in a way that it's misleading. And even if you do have sort of a reliable survey behind a certain claim, if you use it, for example, if you test a particular product or you test a particular model, and then you go and you use that survey, which is statistically sound for the entire brand or every model in that category, then once again, you're going to find yourself having a problem, because all of a sudden a survey that was actually accurate still becomes misleading depending on what the advertisement is. So that really comes down to that last point of making sure that when you do this survey and when you spend all this money to get a reliable answer for some sort of statistical metric that you want to put out there, that it's actually answering the question that you have, and that's what you're going to use it for in terms of advertising. All right, so moving down to another one. Right there at the bottom, you may not have seen it. Home improvement specialist approved. See more at www.kanyerules.com.
All right, so I guess the first thing I would say, what the heck is a home improvement specialist? And what's the process for determining whether home improvement specialists have approved claims, right? So first, let's assume that there is an organization or that there are a group of home improvement specialists who test products. We don't have anything here in this claim, advertising claim that proves it. It certainly suggests that if your home improvement specialist approved, then it must be some sort of seal or test that you've passed with minimum requirements that demonstrate that the product works as it's supposed to, and therefore it must be better than someone or some product that is not improvement specialist approved. And even if it were home improvement specialist approved, and you view this claim as that most home improvement specialists, however that might be defined, maybe it's do-it-yourself consumers who use these products on their own, or maybe they're trained home improvement specialists. Either way, you still have to know whether it's approved in a manner that demonstrates that it operates as it's supposed to. And so if you look at it from the standpoint of that you've met these other two requirements that aren't reflected in the claim itself, how many home improvement specialists must approve it in order to make it something that is usable or that is certified in a way? Clearly, the implied claim here is that there's some level of certification or minimum requirements that have been met, but without some kind of more behind it or some more substantiation that can support it, then it could be an impliedly false claim, because there's nothing else to tell a consumer that there's a chance that maybe it doesn't perform, right? And so consumers are going to look at this and say, well, yeah, if it's home improvement specialist approved, then it must be pretty good.
All right. And so another thing to look out for, and this is kind of a fun one, I think we've all seen it, even if we don't know we've seen it, it's fake blogs. And I'm sure we've all had this experience. You go in, you're trying to figure out what new mattress to get for your bedroom, or you're trying to figure out what the best sofa is out there right now. And of course, you go straight to Google, you type it into the little box, and all of a sudden, all of these different websites, which appear to be legitimate home product or other type of review websites, pop up before pretty much anything else. And oftentimes, not always, but oftentimes some of the highest results that you get in those searches are really what we call fake blogs or fake gripe sites. And what those sites end up doing are one of two things. They have some sort of back-end deal with the actual company or the actual product, where they create all of these positive reviews for the product without the consumer actually knowing that for every purchase of the product, they may get a kickback by using some sort of code or by tracking how many times someone goes from a link on their website to the actual product website to buy it. And that causes a couple of problems. One, it is potentially Lanham Act false advertising. Why? Because you are presenting a statement to the customer about the quality of a product that may or may not be true. It's literally false, or it's literally something that you are misleading the customer for. That could be a Lanham Act claim. Also, the FTC may have an issue because they have things called testimonial guidelines. Anybody who actually promotes a product and promotes it by giving a testimonial or giving a review or writing a blog about how great it is, they have to disclose if they have any material connections that customers would not expect. So the simplest one, of course, is if you click on this link from my site to buy this product that I just reviewed, I'm going to get money for that. That is probably the most common one. And if someone who is writing a blog or writing a review of a product does not disclose that fact, then they can run afoul of the FTC. So in this case, we have sort of mocked up a Bruce Home Improvement blog. And here we have a couple of entries from supposed consumers of the Conway Power Blaster. And hopefully you can kind of see it, but I'll read just a couple for you. The first one says, the Conway can strip away anything using any material. I ran out of sand and used gravel from my driveway to finish blasting paint off of my house. Now this goes back to what I was talking about earlier. You know, the idea that they just picked up some random rocks out of their driveway and just put it into this device and it worked just as fine as using sand or using water seems a little bit dubious, but possibly depending on if the product was really made in that way, maybe that's true. Well, let's look at the next one. Not only is the blaster great at removing paint, but its gun-like appearance makes me look tough. I carry it around with me in the city to deter would-be muggers from attacking me. It is working great because I haven't been attacked yet. Conway is keeping me safe. Okay, now this one seems even more suspicious. What is the likelihood? You see the picture of the actual Conway device there, that carrying that around, people are going to mistake it for an actual gun, or people are going to mistake it for an actual safety device. And what is the likelihood that anybody in their right mind would actually try that anywhere on Earth? So let's look at the next one. I work for the county out on Route 95. All day I hold a red flag and watch traffic pass me by. Last week, a car swerved and nearly ran me over. Thanks to Conway's powerful blasting, I was able to blast the tail off the car, rendering the tail lights useless. Thanks, Conway. All right. It seems like an even more suspicious story. What is the likelihood that a device that's meant to clean things off of your driveway would have the power and the flexibility to actually shoot something out strong enough to knock the taillights off a car? Probably not. So think about, I'm sorry to interrupt. Go ahead.
Think about if each of these had a star rating, and each was a 5-star rating, and a consumer then looks at this, say, oh, it's got 5 stars, I'm going to buy it. And these were the reasons that people that created the 5-star review. So here's a 5-star product, and consumers rely on that. When in reality, I didn't read all of them. You probably did, but it doesn't really support the use of the product, right? And so you have to think about whether a blog like this that your competitor is using is creating a false demand or creating a false, not only a false demand, but false rating of the product as to its efficacy.
And we're having some fun here with this, but in all seriousness, this can happen to a company by complete accident, because in some instances, it could be a company not trying to do anything wrong or incorrect or suspicious, but simply want to incentivize people actually reviewing their product. So if you go and you leave a review on this product, you get a free gift, is a good example of that. And companies do this, and companies have tried this, or you get 10% off of, the next premier product you get. That's a sticky question, because now what you have done is you have set up an incentive structure that isn't completely disclosed to your other customers for customers to come and actually leave these reviews. And studies have shown that customers who get gifts for leaving reviews, surprise, surprise, happen to feel a little bit more favorably about the product after that. And so it's a very, very fine line that you really have to watch, because the FTC is very, very focused on this issue of whether or not the reviews on websites and whether or not the reviews on these blog sites actually represent unbiased views of the quality of a product, such that customers will not be misled.
Well, it turns out that there is some special sand that you can buy for the Conway Power Blaster, and it's surprise Conway sand, and it's better sand and better blasting. So what do you think about that, William?
Well, let's go back to some of the things we talked about before. How do we test whether it's actually better sand, and how do we test if it's actually better blasting? You know, in a situation like this, you have to ask yourself the question, is this really making some sort of literal or implied claim that we've actually found better sand or found better blasting? Or is this simply what we would like to call puffery, where we're saying we're the greatest, we're the best, we're the most wonderful on earth, all things that may be opinions and may be not actual facts and not subject to testing, but can be said and can be advertised fairly. But I don't know, Roger, which one do you think this is?
So like so outrageous that nobody would ever believe it type of claims. All right, so I can tell you that this is and this is not by accident since we put this together, but better sand, better blasting is almost identical to the claim that really put out what puffery means, and that is better ingredients, better pizza. Right. And so that's Pizza Hut versus Papa John's. And so when you think about better ingredients, better pizza, the question is, well, is that false advertising? Because aren't you saying that you have better ingredients and better pizza and you don't have any substantiation for that? Well, the reality is that generally speaking, if you use better ingredients, maybe you have better pizza. Depends on what, better than what? What does that mean? Better pizza? What is better pizza? One better than the other? Does that mean it tastes better? Does it mean it looks better? Does it mean it's made with better ingredients that cause the crust to rise higher? Or are the ingredients the toppings, right? So what the Fifth Circuit found in this case is that when you're just saying better ingredients, better pizza, that's not a claim of superiority or comparative claim. It's just a better ingredients, better pizza. That's puffery, if you will. And if you think about it long enough and look at it the right way, you would think, well, it makes sense. If I have better ingredients, I'll have better pizza. But what happened the second time around is that Papa John's started to use comparative advertising, talking about their pizza as it relates to other pizza that can be purchased by a consumer and delivered to the home, specifically Pizza Hut pizza. But as soon as you start making a comparative claim, even if they're not done at the same time, but when you start looking at the comparative claims and then either a tagline or a separate advertisement where there's a campaign that just says better ingredients, better pizza, it becomes a situation where you see a lot of comparative advertising and you see the phrase better ingredients, better pizza. All of a sudden that better ingredients, better pizza becomes a comparative claim without substantiation. And so the Fifth Circuit said in the context of broader comparative advertising, then it is a misleading claim because it's no longer puffery.
So we fast forward to trial. Sandstorm wins. Sandstorm proves false advertising, and the jury awards $20 million. And so then time rolls on. Conway files post-trial motions under Rule 50 seeking judgment under the Lanham Act as a matter of law and argues there's no evidence of causation.
Speaking of time rolls on, the code for the CLE for today's presentation is Lanham 2023, LANHAM 2023. Sorry, go ahead. So it's me?
Yes, you.
Okay. So, there
it goes.
All right. So if you're trying to determine what your damages might be, and you're looking under the Lanham Act, you're going to see Section 1117, and that talks about damages in a Lanham Act claim, 15 U.S.C. 1117. So what are your choices? as a plaintiff? Well, you can go for defendant's profits. You can go for your damages that you suffered as a result of the advertising. You can go for the costs of the action. And there are other, possibly there's a treble damages. You can show willfulness in making a false claim, always a very difficult thing to do. Let's talk about what some of those are. What people seem to really want to focus on, well, I want to get the profits of the plaintiff. And the reason they say that, the reason they want to do it can vary. But if you're trying to prove damages, or are you trying to get profits from the defendant, it may be easier to calculate the defendant's profit than it would be to prove your own damages. And what situation could that be? Well, if you think about trying to prove damages in a case, and there are two of you in the marketplace, or the two main players that have most of the market share in the marketplace between similar identical products, then it may very well be that even as a plaintiff, and even though you may have been damaged by the defendant's advertising, your market share or your sales are going up, even though you're being harmed by the defendant's advertising. And so it's pretty hard to argue, well, I've got damages because I should have had those sales, but this defendant took those sales from me. It's harder to convince a jury that you're being damaged when you're making more money while this is happening. And so you look at the profits that the defendant made and try to go after those. And there's some additional things you need to show. For example, the economic or reputational injury flowing directly from the deception wrought by the defendant's advertising. In other words, your reputation is being harmed, or you're losing shelf space. But there has to be some nexus, some causation there. And the defendant's profits would otherwise be unjust enrichment, because you have to show that you would have otherwise got those sales but for this false advertising. It's much easier to do when there's a comparative advertising claim than rather just a general superiority claim. I looked at both of those claims. And when there's either just two players in the market, or the two biggest players in the market have 70, 80% of the market share, and the rest are just small bit players, then it's easier to show that you would have gotten those sales but for the advertising, because they came from yours rather than the other players in the marketplace. All right. So just a couple other things with respect to damages. I mentioned causation. You have to show causation. If you can't prove lost sales or profits, you have to show that you're otherwise harmed. And so you can't recover profits from the defendant without that kind of a showing. And you see two cases on the screen here, one from the Sixth Circuit, one from the Fifth Circuit, and they're in agreement that where a plaintiff who has brought a Lanham Act claim for false advertising and hasn't shown evidence that the defendant was unjustly enriched, then the plaintiff can't be permitted to recover defendant's profits. All right.
So we were talking about causation earlier, and here I think we have just a few potential exceptions to that rule, and that is when there is either willful deception that can be proved, where it's very, very clear that the defendant has done this wrongful act, has misled the customer on purpose, and in a two-player market. And that was sort of what Roger was talking about earlier, a situation where it's sort of like, If the market is such that if I don't get the sales, you get the sales, then any sort of wrongdoing in terms of misleading customers, it's kind of common sense that there will be sort of causation, that anything that convinces customers to come to them as opposed to you, because there's only two people there. And so we have a little case here that sort of says, to satisfy the Lanham Act zone of interest requirement, a plaintiff ordinarily must show economic or reputational injury flowing directly from the deception wrought by the defendant's advertising. That's what we were talking about earlier. However, injury may be presumed for a misleading comparison to a specific competing product because such an advertisement necessarily diminishes that product's value in the minds of the consumer. So here, once again, we have a situation where it's kind of like I'm talking about Pizza Hut and I'm Papa John's. Necessarily what I'm saying and anything that I'm saying that's misleading is going to diminish Pizza Hut. Or if it's only Pizza Hut and Papa John's and I'm just saying in general, hey, like there are no other better pizza places in the world besides me, but there's really only one other pizza place, then to a certain extent, injury can be presumed without having to go through the trouble of showing that the injury directly flowed from the statement.
And that is with respect to, of course, a showing that there is false advertising. Mm-hmm. And oftentimes clients are frustrated because of what's going on in the marketplace. And when they're looking for advertising advice, what's been shown over and over and over again is that the most powerful advertising is direct comparative advertising. In other words, you're saying you're specifically better than a competitor, and you're saying it by name. And when, again, those are the two players who have most of the market share, and they're the ones that are fighting with each other, it's pretty clear that consumers are thinking, all right, these are the biggest players. One's claiming better than themselves. This one says their product doesn't work and his product works better. Well, there's nothing really more to say is that, look, they named me specifically in their advertisement. Of course, I'm losing the sale because they're saying they're better than me. I should buy theirs rather than mine. So that's really where this proposition comes from. And this is a fairly recent case that was affirmed by the Second Circuit in New York.
And this slide just kind of is a case making the point on sort of willfulness. And the idea here is more of sort of equity as opposed to what we were seeing earlier in terms of, showing causation. And it's really, as the court states, under any theory, a finding of defendant's willful deceptiveness is a prerequisite for affording profits, or at a minimum, willfulness should be considered in determining the equity of awarding defendant profits. So just another way to sort of look at, not looking directly at the causation issue here, looking at an equity issue of if they did it on purpose, if they're purposely trying to affect the market with their false statements, then maybe there is some equity at taking away anything that they profited from those false statements, even if it can't be shown that it was directly taken from the particular plaintiff.
And where you might see that, and there are a lot of demonstrations with respect to consumer products. For example, the types of products that are used for cleaning or polishing or other things that air purifiers and things like that, where there's a demonstration that may seem pretty outrageously phenomenal that this product is so much better than the other. Oftentimes something is looked at as whether the demonstration has been rigged. And it happens all the time. Many times it's happened through a lot of the cases I've done where the deeper you look into the demonstration, and your client will likely know exactly what their product can do and how it compares to the competitor's product. And they'll say, there's no way that's the way this worked. This is a rigged demonstration. And it allows you to go and dive deep into how that demonstration really was performed and how it may have been some cheating going on. And that's the kind of willfulness that if you can show it, you can get not only a preference that your claim is good and you should get damages, but you would also probably get enhanced damages or something like that.
So we've talked about what a claim may look like. We've talked about what the potential damages are. We've gone through the sort of hypothetical situation and kind of discussed how these things might apply. What if you see it? What if you go on the website right now and you see someone talking about your company or talking about your product in a way that you think is false or misleading, such that you may have a Lanham Act claim? What is the first step you may want to take? And that's a good question. And it depends on a number of different factors. And a lot of times where we will start, or where we advise our clients to start before they just bring a lawsuit or before they notify the National Advertising Division or something to that effect, is, well, let's send them a letter. Let's send them a letter and say, look, we know what you're doing. We think it's a violation of multiple federal and state laws. And if you do not stop, we will sue you. That is what we call a cease and desist letter. And there are a couple of questions that come up when you try to decide on whether or not this is the actual right approach. One, do you even want to let them know? Is this a situation where it will be advantageous for you to tell them so that they just stop? Or has it potentially gone so far and damaged you so much that you don't even want to notify them of it? You just want to bring the case in court and be able to sort of catch them off guard and begin to build your case for potential damages. Is there a possibility of an amicable resolution? Is this something that you feel like is not been going on long enough, or small enough, or is easily fixable enough that you might be able to just get on the phone with the other side and say, hey, look, we need you to make these small changes because we don't feel like it's completely accurate. Don't know if you didn't have all this information, but now we'll give it to you. And maybe you can come to some sort of way to sort of fix it without spending the money on an actual litigation. Is there a risk of declaratory judgment? All right, if you send this letter and you put them on notice, will they run into court and try to sort of declare their own advertising to be actually correct and not misleading? Is that something that you're going to have to deal with and then find yourself in court anyway and have to oppose? And this kind of goes to all of these things. Is the letter going to slow the process up? I mean, the whole point of sending a cease and desist letter is usually in the hope that they will actually stop what they're doing without having to bring a lawsuit. If there are different contextual issues that it seems pretty sure that if you send this letter, all it's going to do is make the process longer as opposed to just seeking other relief, then maybe it's not the right way to go. And then what if you have to sort of respond to the demand letter? Then you have to kind of really begin to evaluate your own advertising and say, all right, now that I have this information, do we feel like this is actually literally false? Is this defensible? Is this puffery? Is it actually substantiated? All these questions, when you start to actually look at your own advertising that without the information from a potential cease and desist letter you may not have asked before, are the questions you really want to seriously and objectively begin to ask yourself and hopefully your counsel at some point, whether or not this is something that you need to deal with, or is it something you want to respond to and just pretty much say, hey, we're not doing anything wrong. Can you adjust the ad, whether you're wrong or not? Is there a way to still get the results you want from the advertising campaign, but still fix the issues that are pointed out by the cease and desist letter? And in some instances, that's the best fix. If you can go in and it's not ridiculously expensive and it's not going to actually derail sort of the message you're trying to get out to your consumers, sometimes it's just better to be like, hey, we'll take down this chart, or we'll adjust this number, or we'll say this in a different way. And if that makes you go away so we don't have to pay, Roger and I to actually answer the letter, then maybe that's the way to go too. And then kind of going back, do you want to bring a declaratory judgment? Are there counterclaims? And this is one of the things we talk about a lot with our clients. And that is, oftentimes there's leverage to be had here. In this industry and sort of the advertising claim world, a lot of times some of this is like self-regulatory. Someone sends a letter and says, I don't like your advertising. Then you look at their advertising and it's like, well, you're doing something similar. You're saying this about my product that I don't like. And sometimes that's just a conversation where it's kind of like, okay, we both have issues. Maybe they're both legitimate. Maybe they're both not, but like maybe we can meet in the middle and try to sort of resolve this without sort of spending more money or creating more expense or going through a long court process or going through a longer, process with the NAD. And those are all sorts of ways that these things can get resolved without ever actually involving any sort of court or any sort of other organization to resolve the issues for you.
To William's point here, and we've been doing this a long time, and most of our clients now, particularly those who are bigger bigger clients in the sense that they have a pretty good piece of the market share in any given portion of the industry. What they do and what the general counsel does and what we recommend they do all the time is that they find their counterpart at their best, at their main competitor. And when they do that and the counterparts, the general counsels are able to speak with each other, what happens in a case where there's a claim to be challenged, a letter gets written, and it's often a cease and desist letter. And it lays out where one company thinks the other one is falsely advertising. And what exactly happens, as William says, is then the company who receives the letter looks at the other company. And what happens in the way these things self-regulate, as he points out, is that one company will write the letter, hey, you're falsely advertising, you need to stop right away. Consumers are being misled. Here's how. Unless you've got a test that can substantiate this and provide it to me, you need to stop. And the other one will look at that and say, all right, we might have some exposure. Let me look at their advertising. They look at it, they find claims that are false. They'll write back a letter saying, I've looked at your website and your packaging and retail, and I see these false claims that you're making, and this is why they are false, and this is why you should stop. And they go on and on about why their other size claims are false. And at the end, they say, we're just phasing out this advertising and we're refreshing it. And so while we disagree that the advertising of ours you claim is false is 100% true, but turns out we're changing this, resetting our ad campaign for this quarter, and this will be phased out. And any other side will respond similarly. And that's how, in actuality, this self-regulation works out. And it's primarily because there's a relationship between either the principals or the general counsels of each side, and they know how, they know how they can stop things from escalating if they can both find a way to get what they want and save face. And that's often how it is in almost every dispute. But here, your company, your GC, your principal, CEOs, whatever it might be, are putting themselves in a position where they can do it. And even if it's at a level where you otherwise might seek a temporary restraining order or preliminary injunction, the letter basically says, hey, you're doing this. This is very, very serious. We need to know today by 5 o'clock, or we're going to have to take action, emergency injunctive action to solve this. And even in a situation like that, that can be de-escalated very quickly because of the relationships that there are. If there's ever a practice pointer in a seminar like this, that's it, where people are able to set up a situation where they can de-escalate a situation or de-escalate an issue very quickly, just based upon having that relationship in advance. All right, where to challenge? Well, there's all kinds of things you can do, and some of us, William and I specifically, love going into court, but there are other considerations on how you deal with this, and we're always looking for the best solution for the client. And many of the considerations that you have to take is, for example, burden of proof, what the timing is, what evidence you have, what the cost is, and those are things I just barely touched upon, and when we were talking about de-escalating a situation or being able to save face or changing advertising in a way that you don't have to admit any wrongdoing. But most importantly, if you think about each of these issues as we go through the next couple of slides, you'll see what we mean. So one thing that is sometimes used, but not that frequently, is an FTC trade complaint. As all of you probably already know, Section 5 of the FTC Act deals with consumer deception, and only the FTC can enforce the FTC Act, although states have these mini FTC Acts, often called Deceptive and Unfair Trade Practices Acts. But the FTC will actually consider complaints filed by a company in a marketplace in a particular category or segment where they're asking the FTC to look into some bad practices that someone's doing in that sector. And it can be very effective if the FTC wants to play. And typically when it's a company versus company, the FTC doesn't really want to take sides and doesn't want to waste their scarce resources in taking sides on a fight between two competitors. But it can be useful because, remember we talked about burden of proof. Under the FTC, Section 5 of the FTC Act, the burden of proof is on the advertiser to provide substantiation for their claims. In other words, a reasonable basis. And the burden of proof is not on the FTC to prove it's false, like a plaintiff might do in a Lanham Act, but it's on the advertiser. If the advertiser doesn't have substantiation, that's a big problem. And even if it does, it still has to deal with the FTC. An investigation might open, and the FTC might find other things. The problem for the plaintiff or the challenger in this situation is once you make your claim or you file a trade complaint and you lay it all out for the FTC, you never hear another word, you don't get to participate, you don't know what's going on, and you don't know if anything's going to happen. And you don't know whether the FTC is going to pursue it or not. And so you sit there and wait, and meanwhile, your competitor is out there making false claims or worse. But so an FTC trade complaint is one of those ways to challenge a competitor, but it's very rarely used, but there are very specific ways in which it can be used very effectively.
Another way to go, and I sort of mentioned this earlier, is the National Advertising Division, which is pretty much self-regulation for advertisers. Anybody can come and say, hey, I think my competitor is doing something wrong. I want to start an action. And the NAD will pretty much arbitrate the dispute. Now, the problem with the NAD is that it doesn't have any real enforcement power. Unlike going to court or unlike if the FTC takes action, they don't have the independent power to actually enforce their decisions. They're really sort of more of advice for what they believe should happen. However, if for some reason an advertiser who is doing something that the NAD thinks falls afoul of advertising law does not actually remedy it in the way that to the NAD's satisfaction, they can and often will ask the FTC to get involved in do an enforcement action, which kind of goes back to the last slide of kind of going through the process again of kind of losing a little bit of control. But hopefully this is enough of a stick to make your competitors want to actually follow the NAD recommendations, and is a way that potentially you can address this short of actually starting commercial litigation. Things to consider besides those is the burden of proof is on the advertiser, sort of like with the FTC. So unlike in commercial litigation, it's not the plaintiff who has to prove that there is a false statement. It's really up to the advertiser to show the NAD that all their claims are substantiated. And also there's a disadvantage because there's really no discovery. You don't get to sort of see all of your competitors' stuff in terms of like what all the things they're doing that might potentially harm you and get all that information. But the NAD will look into it and hopefully, give a decision in a reasonable amount of time, although sometimes the process can take just as long or longer than litigation.
Another place to consider is the Lanham Act. And this is in court, obviously, you're in federal court under the Lanham Act. And you typically would bring state claims as well. I mentioned before, the Deceptive and Unfair Trade Practices Acts. Almost every state has one. They're often called mini FTC acts. And so the burden of proof is still on the challenger if you're bringing the claim. Now, how do you, because you're challenging the other side, you're typically bringing a Lanham Act claim. And unless you get the state to bring a claim, the burden is still on you, the plaintiff, to show the claims are false. But if the state jumps in and wants to participate, then the defendant is going to have to respond to the state by demonstrating their claims are truthful. So it has a really big stick in the Lanham Act, and that's seeking emergency injunctive relief, a temporary restraining order, which you can get in a matter of less than 24 hours on occasion, or preliminary injunction, which can go out to maybe 3 months. and still be considered an emergency. And if you file it early enough, you can get expedited discovery, which you're likely going to want, whether you need it or not. And then we're about out of time here. And so you have to consider how significant is the claim, right? Because it's going to be very expensive, more expensive than any of these other remedies. But if it's a significant claim and it's really harming your company or your client, then you're going to want to go in and get the relief as quickly as possible. You want to enjoin the false advertising because it's really hurting the reputation. You have to obviously prove that you're irreparably harmed, can't be satisfied by money damages, but such as losing shelf space, losing reputation, obviously losing customers in a manner that can't be reconverted to you. And so you may want to bring that claim right away. And I mentioned how before how that can be done even by agreement between two companies. You do have a risk of counterclaims, and there is discovery, and it can be both good and bad. I would say almost certainly when we're involved in these and we're defending, you can expect a counterclaim because there's always something. And so that's really how it goes. I know we're out of time, but if you have any questions, and you can follow up with us, and we'll make sure we respond to those questions. And if you want to have a conversation, please do. And the one more time, I'll give you the code is Lanham 2023. That's LANHAM 2023. And I believe Lanham is all caps.